Good afternoon. Hopefully everyone can hear me, and welcome to our webinar on Article 3 and Article 8 health claims following AM Zimbabwe in the Supreme Court. I am going to introduce everyone. My colleague Miranda Butler is going to address you in respect of suicide claims. Then Mark Symes is going to speak about fitness to fly cases. And last of all, David Sellwood is going to talk about Article 3 claims based on destitution and humanitarian conditions. I will start off by really just a quick zoom through history, partly because the historical cases, I think, still potentially have relevance today, and then really just some ideas post AM Zimbabwe as to how to put Article 3 claims. The session is being recorded and will later be available on our YouTube channel, so just be aware of that. By all means ask questions, but it's probably easiest if you put them in the chat, which appears on the side of the screen. Right, I am now going to attempt to share my screen with you. Hopefully will work. So, as I indicated, we're going to look briefly at the history of the case law. I don't think the case law did in fact begin with D in 1997, but that was the first major case. D was from St. Kitts. He was facing deportation. He was in prison in the UK. The issue in relation to D was that he was HIV positive. He was having the treatment that was available, which was not at that time antiretroviral treatment. And therefore, there was essentially no doubt that he would die if he was removed to St. Kitts. And the aspects of the case that the Strasbourg court found compelling were the fact that he'll be in pain and suffering, and that he would be living in conditions of isolation, squalor, and destitution because he had no one to care for him in St. Kitts, no accommodation, no financial resources. So this really was the departure. So the issue was there are exceptional circumstances, and this was why they said, even though the state wasn't responsible for the inhuman treatment that he would suffer, it would breach Article 3 to remove him. So as a result of D, essentially there was no UK law as such, but there were Home Office policies which meant that people would in practice be given grants of exceptional leave to remain. And that was really the position until the case of N. The big shift was that by that time, antiretroviral therapy was available and N was in receipt of that treatment. So the House of Lords decided that you have essentially distinguished D and said that you have to show that the person is really a deathbed case, that the condition they have is critical, the stage is critical, and there are compelling humanitarian grounds for not removing the person to their home country. Now, interestingly, Lady Hale said that there may be other exceptional cases with extreme facts. And that was really the bit that you had to try and fit your clients into if they weren't a deathbed case. So, but really the majority said it's got to be critical, they've got to be compelling humanitarian grounds. And in practice, very few cases succeeded. The case went to the Strasbourg court, who essentially upheld the House of Lords for the same reason. They also, perhaps somewhat surprisingly, made comments about floodgates, made comments about the UK and Europe not being a hospital for the world, in effect. And as a result of that, there was a strong dissenting minority opinion where essentially they said the attitude of the majority essentially is moving away from Article 3 and its absolute nature. So that, of course, was a minority judgment, so it wasn't really going to have weight, but could obviously still be invoked in representations. Now, both of those, of course, were HIV/AIDS cases. There are, of course, other cases engaging physical and mental health. I have on this slide really just given a summary of the case law up to the point in Papashvili. It has to be very exceptional or compelling. What happened then in practice was that we would argue and judges would find a breach of Article 8 really is a way of getting round Article 3, because of course Article 8 has to be balanced because of the proportionality exercise. Now the sort of bedrock cases relied on there were Ben Said and adverse effects on physical and moral integrity, and then the case of AM Zimbabwe, where Lord Justice Moses found in a sleight of hand, really, that if you can't just succeed on medical grounds, but if, for example, you have other aspects of an Article 8 life, perhaps family life, then the availability of your medical treatment coupled with a dependency on your family together establish family life. And he found that this would not involve a comparison between medical facilities in the UK and in the receiving country, and so wouldn't offend any principle about the provision of medical treatment. So Article 8, I think, is still relevant and should be argued as a backup, although it is, of course, more complicated now because of Section 117A to D and the need to address the statutory public interest considerations. Other cases in respect of Article 8 that are helpful are JA Ivory Coast, ES Tanzania, where Lord Justice Sedley looked at the contrasting claims in health cases with regard to Article 8 and Article 3, and expressly said, you know, it's a prescribed purpose, the economic well-being, we can't afford to be the world's hospital. You have to balance that against the rights of the individual and the moral duty to help others in need. And they did find in favour of one of the appellants, JA, who had been continuously lawful and really had no prospect of securing treatment. And they found against the other appellant on the basis that that appellant, ES, had the skills and experience to obtain work and familial support. So ultimately, this reminds us that all these cases are fact sensitive. They always have been, and they continue to be. The fact that the case law is now more positive doesn't automatically mean that your case will succeed. Another case that's useful then as now is the case of Akalu. This was a kidney failure case. Now, the appellant in that case had kidney failure and had had a transplant, but she wouldn't be able to continue to receive treatment if returned to Nigeria, and she would die. It was accepted that she was someone for whom the UK could provide healthcare without charge. So that wasn't an issue in that particular case. So this slide sets out a number of principles. They're not necessarily all as relevant now as they were before, but you'll see the types of issues. So for example, again, lawful residence, the fact that previous receipt of medical treatment, this in a way stems back to a point made as long ago as in D, which was about the assumption by the state of responsibility for the person concerned in terms of provision of medical treatment, bearing in mind that D was in prison and was being treated in prison, and essentially that was part of the state's positive duty. I think in Akalu, it was also the fact that she had had a transplant. So there'd been that investment in her health. So while she didn't need specific treatment for kidney disease, she needed access to treatment and support to make sure that she remained well. So I think those potentially are still useful principles when one's looking at Article 8, bearing in mind proportionality. I've also made reference here to GS India, which, although not helpful, is just part of the continuum. And this was an attempt in the UK to essentially get the Court of Appeal to depart from N on the basis of the imminence of the death of the appellants due to kidney failure. The facts being that they would die in approximately 3 weeks in severe pain. And the court robustly said that essentially they were still bound by N. Happily, at the end of 2017, I think, we had the case finally in the Grand Chamber of Papashvili. And the Grand Chamber there, having reviewed all the case law, said that it was really time to clarify the approach that had been taken to the category of other very exceptional cases, which they had previously flagged in the case of N. And they set down the test, which has since been adopted in AM Zimbabwe, which is that you have to show that there are substantial grounds for believing, although not at imminent risk of death, you would face a real risk on account of the absence of appropriate treatment or the lack of access to treatment in the receiving state, of being exposed to a serious, rapid and irreversible decline in one's state of health, resulting in intense suffering or a significant reduction in life expectancy. There are quite a lot of different elements there that can be unpicked, or potentially that you can argue in relation to individual applicants. But just to pull out a few of those, the first of those is obviously there have to be substantial grounds for believing. So the medical condition has to be a very serious medical condition. The applicant really needs to be in receipt of medical treatment. Now, the other interesting aspects of this case is that if a prima facie case is raised, you have medical evidence, you have the case of ill health, then essentially the authorities of the returning state, i.e. the UK, have to dispel any doubts raised by the evidence that you've adduced. And that may extend to obtaining assurances from the country to which the person is being returned. So I'll look at slightly later at the practicalities of that, but clearly that is very helpful. And it will create a situation, which I've had on one case so far, where the Home Office actually concede that the test in AM Zimbabwe taken from Papashvili is met, although that has simply resulted in the grant of 6 months limited leave, which is possibly why they decided to concede that aspect of the case in order to focus on being unhelpful in relation to other aspects. So AM Zimbabwe was heard at the end of last year, judgments on the 29th of April, and finally it has been incorporated into UK law. I should say in between Papashvili and AM Zimbabwe, there were a number of attempts to have the principles incorporated, including the case of EA Afghanistan, and then most recently, and referred to slightly later on, the case of AXB in the upper tribunal. But all the lower courts said correctly that they were bound by N, and the matter had to go all the way up to the Supreme Court for there to be a shift. What the courts say is not in essence hugely different from Papashvili in terms of the principles that are there. So you have to produce evidence, you have to show their substantial grounds. You present your evidence, the returning state can seek to challenge or counter it, or perhaps concede. Since AM Zimbabwe, well, prior to AM Zimbabwe, there was an application in Strasbourg, the case of Savran against Denmark. That was an Article 3 case. The facts are set out briefly here in relation to someone suffering from mental ill health, a Turkish national and long-term lawful residents in Denmark. And the court found in his favour, but there was an appeal to the Grand Chamber, which has recently been heard and judgments awaited, as to whether there would in fact in practice be an Article 3 violation. The issue there, the Danish authorities were in touch with the Turkish authorities. This wasn't a case where there was no treatment available. The issue was really the adequacy and whether the specific treatment that the psychiatrists in Denmark said the applicant required would be available in Turkey. So it will be interesting to see how the Grand Chamber deal on the particular facts with this case. As I mentioned earlier, the case of AXB, which is in the upper tribunal, although it predates AM Zimbabwe, does engage in quite a lot of detail with the both substantive and procedural Article 3 aspects of that. So that is worth looking at, in particular paragraph 77 to 125. So I have just done a little summary here in terms of dealing with specific cases. So the first is, does the applicant have an arguable case? Is there a prima facie case based on health? And does it reach the Article 3 standard? So this will involve obviously not only looking at the particular facts of the applicant's health, but also the situation in their country of origin. What are the treatment options? What treatment's needed? Is that accessible? That will of course also include affordability, which was an issue in the Savran case. It will, I think, always be helpful to have medical evidence, but probably also, if possible, expert evidence about what's available in the country of return, particularly bearing in mind the standard of proof. Article 8 arguments should be raised at the outset, and there should also be consideration of the previous case law in sections 117A to D. The Home Office guidance in relation to healthcare claims has not yet been updated since AM Zimbabwe. The last update was on the 20th of May 2014, but it surely must. So it is, of course, always worth checking to see what their position is. Another issue that may arise will be during case management, because I think these cases, if they go to appeal, are going to require quite strict case management, will be to try and insist on strict deadlines for the Home Office to obtain assurances, rather than it just being an open-ended aspect. There are numerous authorities on the meaning of assurances. Obviously, the case of Othman, that was the Abu Qatada challenge to his deportation. The assurances there were very specifically about whether his home state would ill-treat him. But also Tarakel in Switzerland, the issue there was the conditions that the proposed returnees who are an asylum-seeking family under Dublin would be exposed to. And the Strasbourg court held that the Swiss authorities had to obtain assurances from their Italian counterparts as to the facilities that would be available to them. And then most recently in May of this year, the judgment in the Court of Appeal of Devani, D-E-V-A-N-I, that's 2020 EWCA CIV 612, which was an extradition case. Not entirely helpful, in the sense that on the facts of that case, the court said there's no principal assurances have to eliminate all risk of inhuman treatment. But given that in these cases, it's going to be very specific assurances in relation to the availability of medical or health treatment, it obviously needs to be looked at. The standard of proof, by the way, it was held in Davani, was the balance of probabilities in terms of whether the assurance was binding, really. So yes, that's what I want to say so far. Obviously, any questions, put them in the chat, or I can answer them as we go along. I am now going to stop sharing so that Miranda can take over. Thank you.
Thank you very much for that, Rebecca. It was a pleasure to hear that. I'm now going to attempt to share my screen as well. Hopefully everyone can see my slides. Do let me know if not. I'm going to be speaking about Article 3 claims based on a risk of suicide. I'm going to piggyback on a lot of what Rebecca has said, because there is a substantial degree of overlap between the two areas. Rebecca's talked about how high the threshold can be for Article 3 claims based on what I'm going to call physical health risks. And the standard, as I'm sure all of the practitioners here will be aware, is even higher in suicide cases, perhaps because of sometimes a tacit concern on the part of the courts about the proactive decision of someone, albeit someone in extreme distress, to take their own life, and concerns about imposing positive obligations on states in that context. As AM Zimbabwe doesn't directly address the issue of suicide claims, it's important that we go back and look at what is now some fairly old case law, the cases of J and of X and Y in the Court of Appeal, going all the way back to 2005 and 2009 respectively. They both concern Sri Lankan applicants who had been tortured in Sri Lanka and who had significant mental health problems as a result, and who claimed that they would commit suicide if returned to Sri Lanka. In J, Lord Dyson upheld the decision at first instance, rejecting the Article 3 claim based on suicide risk, and in so doing set out 3 guiding principles for courts to apply when considering suicide claims. Firstly, Lord Dyson asks us to consider the level of severity of the treatment which an individual would face on removal. And as I've already indicated, this is set at a minimum but high level of severity. And Lord Dyson refers to the language in ULA, namely an affront to fundamental humanitarian principles. Lord Dyson then indicates that we have to focus on whether the suicide will be a foreseeable consequence of the removal. It's not enough to show that there is a risk, even a high risk, of suicide on return. Rather, practitioners are required to show that that suicide will be caused by the fact of removal. The third principle that Lord Dyson sets out is one which I imagine anybody who's seen an Article 3 refusal letter probably will be familiar with, reminding us that the threshold is particularly high simply because it is a foreign case. What Lord Dyson means there is he means that we're thinking about the risk of suicide in the country of return, as opposed to the risk of suicide upon notification of a decision to remove or during the process of removal. If we are considering a suicide risk after that stage, after you've been returned, then the threshold is going to be particularly high. That said, we are given cause to hope, and we are told that Article 3 claims can, at least in principle, succeed in suicide cases. But there are two important factors that the Court of Appeal directs us to consider. Firstly, whether the claimant has a well-founded fear of ill treatment, which has an objective foundation. Therefore, it's not enough to say, I am concerned, I'm worried about going back, I'm extremely distressed, and that fear is subjectively real to me. It is important that that is at least linked to an objective foundation of ill treatment on return. And then, along the lines of what Rebecca's just been discussing, a very significant question will be whether the receiving state has effective mechanisms to reduce the risk of suicide. So considering domestic healthcare and its accessibility and adequacy. So on those facts, Lord Dyson rejected Jay's claim, in large part because Jay was someone with family in Sri Lanka and who would, he concluded, would be able to access healthcare on return that would sufficiently mitigate the risk of suicide. The only successful claim based on suicide I'm aware of in the Article 3 context is Y and Z. A few years later, as I've already mentioned, this was a somewhat factually analogous case, but the facts of this case are worth noting. They are extremely severe. X and Y were a brother and sister who had not only been detained and tortured by the Sri Lankan authorities, they'd been subjected to sexual violence, and the entirety of their family, both immediate and extended, had died in various different tragic circumstances in Sri Lanka. The facts were therefore extremely stark, but nevertheless they were unsuccessful at first instance, and appealed to the Court of Appeal, where the leading judgment is given by Lord Justice Sedley. In this case, Sedley walks a fine line, perhaps I should say around Jay rather than through Jay. He builds on it by saying that, well, even though these individuals can't show that they have a well-founded fear of persecution on return, even though their fear of mistreatment by the Sri Lankan authorities lacks any objective basis, there is still an independent basis for their fear, given their mistreatment by the Sri Lankan authorities previously, and therefore that genuine fear could fall within the fifth principle in J. And so what Sedley does is Sedley distinguishes between what he refers to as naturally occurring illness cases, where simply you are someone with acute mental ill health which leads to a risk of suicide, and anticipated self-harm, which is at least materially caused or contributed to by the domestic authorities' acts, in this case, the detention and mistreatment of X and Y. On the facts of this case, Y and Z were found not to have access to adequate treatment on return, in part because they would be so unwell, and because they had no family or other supporters to help them access the local health service. In those circumstances, the Court of Appeal was willing to find that there be an Article 3 breach simply because of the extremely high likelihood of suicide as a foreseeable consequence of Y and Z being removed. So this is the backdrop in suicide cases before we come to AM. As Rebecca's already indicated, the Supreme Court does not, it's talking about HIV cases, it doesn't discuss suicide claims. It makes passing reference to AXB, which amongst other things deals with the question of suicide, but does not consider it as a suicide case or discuss it expressly as such. I was involved in an ongoing judicial review at the time when AM Zimbabwe was handed down, and the judicial review turned on the matter of Article 3 suicide risk. In that case, we were invited to make submissions on the question of what difference AM Zimbabwe might be said to make to Y and Z and also J. And counsel for the Secretary of State said that the Supreme Court's decision simply made no difference, and that the Papashvili principles, as now incorporated at a domestic level, didn't require any departure from the Court of Appeal's previous case law. That wasn't accepted by the judge in that case, and recently at a hearing, I was told by a first-year tribunal judge who expressed some surprise that there might be any dispute over this, and said that they thought it simply wasn't in dispute that AM would apply to all claims, including suicide claims, under Article 3. I think that must be right, and we should certainly be arguing for that as the status quo. The reasons why I think that must be right is, firstly, to my mind, there is no principal distinction between physical risk claims and suicide risk claims. They arise on the same principles, and in fact this has been recognised by the courts, including more recently. Whilst originally Jay suggested that the health and suicide cases aren't precisely analogous, more recent Court of Appeal decisions have elided those differences and have said, in fact, the similarities are more important. And RA Sri Lanka and AXB both simply say we should be applying the N physical healthcare threshold in suicide cases. So I think that we have strong support in case law, and we also have important arguments to make as a matter of principle. The question then is, well, what does it look like to apply the Papashvili and AM Zimbabwe standards in a context of suicide claims? Of course, the court has been talking about HIV claims and has developed and formulated its language on that basis. So I'm going to pick out bits of the language that I think are helpful to apply in suicide cases. Firstly, I think the language around a serious, rapid and irreversible decline is very helpful, because often in suicide cases, what we're talking about is that somebody's mental health will acutely deteriorate on removal, given a variety of factors, separation from support structures in the UK, and exposure to perceived or actual risks in the receiving country. In J, it was argued that the standard that should be applied in suicide cases should be a substantial increase in the risk of suicide. And I wonder if we can build upon the language of a substantial decrease in life expectancy, so as to construct an argument that that should be a basis for revisiting the test that was put forward and rejected in J, given that the threshold is now a lower one and it's inappropriate to be applying the N-style extremely high threshold that the Court of Appeal in J and subsequently has been applying. Finally, I think the language of intense suffering is relevant here. If your acute psychiatric deterioration leads to intense suffering, I would suggest that there's no proper basis for distinguishing that from intense physical suffering in the healthcare context. And once again, I think this is an argument for incorporating and applying the principles in AM Zimbabwe in suicide claims. The procedural approach and focus on risk mitigation that is set out in AM Zimbabwe is also helpful to us in suicide claims. Rebecca's already walked us through the onus on an applicant to adduce evidence giving rise to a prima facie case, and then the concomitant obligation on the Secretary of State to dispel any doubts raised by that. Similarly, that's what we should be doing in these cases. We should be putting forward a robustly constructed and well-evidenced case as to the likely breach of Article 3, and then requiring the Secretary of State not to respond with generic assertions about the adequacy of healthcare and in particular psychiatric healthcare in the receiving state, but to explain why that will be sufficient given the circumstances and position of this particular applicant. Applying that or boiling that down into a few practical points, I think that that merely making an assertion of suicidal risk or ideation will be woefully inadequate. What I would be looking for in these cases, if possible, would be a medical and expert assessment of the severity of the risk in an individual applicant's case. Thinking back to J and Y and Z, we should be thinking about what the basis of that risk is. Is this somebody whose psychiatric illness arises as a result of experiences in the country to which they're to be returned? And the expert evidence should be walking a reader through how psychiatric and suicide risk will change before, during, and after removal, what support will be necessary. I also think that country evidence is likely to be essential, not just looking at the shortcomings of the local health service, but whether this individual applicant would be able to access it and why. The courts, for instance, in J, have been quite willing to accept arguments that somebody has a family member in the country of return, that person will support them in accessing healthcare. And so in constructing these claims, we should be thinking very carefully about addressing an individual's circumstances and what social, personal, financial, even discriminatory barriers that there may be to their accessing healthcare, and explaining how that gives rise to a high suicide risk in AM Zimbabwe terms. Thank you. That's everything I wanted to cover at this point. So I'm going to stop sharing my screen and hand over to Mark.
Hi there. Thanks very much for that. So my short talk is on the question of Article 3 violations and its interaction with the fitness to fly phenomena, as it's often described in immigration and public law circles. And so what the backdrop here is that quite often the practitioner finds themselves in a position where their client is detained and facing removal and has something by way of health problems, quite significant problems often. And we also know, of course, that there is a public law duty recognised in all kinds of cases in general public law, right back in Tameside, in more modern immigration detention public law, in cases like O in the Supreme Court and VC. And we also know that there are doctors in immigration removal centres who are often called upon by the Home Office to assess the fitness to fly. And another thing we know is that there's a various set of inspirations in terms of the material available to us that we can find and refer the Home Office to in terms of a policy matrix. So, for example, we see that the returns preparation guidance, obviously all this guidance changes constantly, but last time I looked, this guidance existed and said this kind of thing. I'm willing to say that much. So the returns preparation guidance has said in the past that fitness to fly should be assumed, and if there's significant doubt, confirmation should be sought from the relevant healthcare provider. I suppose from the Home Office perspective, that is indeed the Immigration Removal Centre Health Department. Also, the enforcement instruction and guidance say that if a person's medical condition is advanced as a reason for delaying or discontinuing removal, full medical details must be sought and treatment options investigated. And there's even a suggestion there that they should be looking at the country of origin evidence for themselves. Another source, not internal to the Home Office, is the Civil Aviation Guidelines. And this is the main area for people whose behaviour is unpredictable, aggressive, disorganised or disruptive, all of which could apply particularly to people with psychological issues in relation to their fitness to fly. And the guidance goes on to say that air travel will be contraindicated in terms of unmanaged as opposed to well-managed psychological conditions. And even people with well-managed psychotic conditions might require an escort to ensure regular medication and to assist in case of problems. So there's the sort of guidance and policy matrix that we have to refer to. And the little question that interested me for the purpose of this session was disclosure and the fitness to fly assessment itself. So quite often, as I've said, one comes across people who really don't seem very well at all and who are facing imminent removal directions. And the mode by which their fitness to fly is assessed tends to be a last-minute assessment by a doctor who may, I suppose, be the treating doctor, depending on how the immigration removal centre is set up. And of course, the chronology tends to be rather a speedy one. The person will find themselves facing removal. A lawyer, may have come on board at the last minute. The fitness to fly assessment will be carried out at the last minute. That's the nature of the beast, really. And of course, it won't be disclosed. In fact, from what I see of these cases, their disclosures of these assessments seem pretty rare. Even when there's a full disclosure of everything on file, it seems to be one really has to chase after the fitness to fly assessment to actually get hold of it. And so the interesting question in the context of Papashvili and the disclosure obligations, which we've mentioned already in Papashvili, is this question of how acceptable is it now in the light of AM Zimbabwe and the other case law, how acceptable is it not to have an undisclosed medical opinion playing a critical part in the case? And sometimes, of course, this medical opinion might be all there is, in which case you can't really blame the Home Office for relying on it. But what about the cases where there's historic evidence of psychological problems and distress at flying times? And what about the situation where there is present evidence? The historic evidence surely might put one on notice that one should be careful and ensure that the treating doctor has sight of that material. Current evidence, of course, creates a straightforward conflict of medical opinion. The case of ASK tells us that the Home Office, if they've got a choice of medical opinion evidence, they have to make a conscientious judgment between those opinions. And of course, if they have to make a choice, then the choice has to be challengeable in public law terms. It could be challenged for irrationality, for not taking account of relevant evidence, for not going far enough, Tameside O duty. What about the legal sources? Well, AM Zimbabwe, here's AM Zimbabwe, yeah, that there's an obligation on an applicant to raise a prima facie case of potential infringement of Article 3 rights, a case which, if not challenged or countered, would establish the infringement, which puts the burden of proof onto the Home Office. So we have that coming from the world of human rights, Article 3. Also, from the world of human rights, much older authority, Chapman, back in 2010, Article 8. There's an investigative process required to safeguard Article 8 rights, and Rebecca told us earlier how often the Article 3 and Article 8 cases may march together pretty well. And that requires the existence of an effective procedural framework under conditions of fairness, including proof and evidence. And then another source, the EU Law Charter of Fundamental Rights. And we've already seen CK, the Court of Justice, look at this question quite carefully and saying that in a Dublin 3 case, this is why it's a Court of Justice case, because it's a part of the, within the theatre of European Union law, it's for the authorities of the member state having to carry out a transfer, and if necessary, its courts, to eliminate any serious doubts concerning the impact of the transfer on the health of the person concerned. And just a side point there, yeah, that although it's correctly said that Papashvili has only just been accepted as the binding authority in domestic law, that's not right in European Union law, in my opinion, because in European Union law, we've always had Papashvili, because the Charter of Fundamental Rights tells us that for European Union law purposes, the ECHR and its interpretation by the European Court has to be the starting point. See Article 52.3 of the Charter of Fundamental Rights. So it seems to me that Papashvili should have been the binding norm in Dublin cases, and I suppose in those rare free movement health cases that we see, or Zambrano health cases, Papashvili should have been the binding authority right back from the moment Papashvili was decided at the end of 2016, I think. So there you are. You have a coming together of multiple sources of law in the context of a series of interesting bits of policy guidance, all of which indicate that there is a distinct duty on the Home Office to properly assess fitness to fly. And if there's an Article 3 dimension suggested by the evidence, to actually, to carry out a full inquiry in order to rebut the possibility that there'll be an Article 3 violation on removal. Just a bit more about these cases, yeah. So, firstly, one has to be clear in one's own mind as soon as possible on taking over the case. What is one's point? Is this simply a fitness to fly challenge, i.e., are you just saying we're not well enough to fly at the moment, but we're not suggesting we require leave to remain? I suppose that situation ought to be reasonably rare, but if that's the case, then perhaps these arguments don't go too far, though I still think the disclosure issues are worth pushing. However, more likely is that the medical evidence available suggests that there would be a human rights violation following removal, in which case the fitness to fly challenge is simply the prelude to an Article 3, Article 8 application, in which case that should be made clear to the Home Office, and the incurrent application should itself be a reason to stay removal for the moment. Another point is, practical point, is always make sure you obtain consent from the client to get their medical records. And I mean, you may have that as part of your standard procedures, but several cases I've done have fallen off their otherwise intended trajectory towards success, because the consent to get the medical records wasn't clearly available. And the Home Office just defended the case, saying, of course, we'd have loved to give you this material, but you didn't give us the right consent. True or not? And then academic challenges. Of course, very often, these challenges are rendered academic by removal being deferred, or indeed by removal going ahead, but more often by deferral. And then it might be said by a judge, well, come on, interesting point, but isn't it academic now? But is it right? Is it academic now? I've just been refused permission, remarkably, on a case where this was our argument that, for sure, we weren't presently facing removal directions, but it remained the case that we were an adult risk level 3 with strong suicidal ideation, to which multiple doctors attested. And therefore, surely we shouldn't be hostage to the same sword of Damocles, last-minute fitness to fly assessment, undisclosed medical evidence, as we'd previously been subjected to. So, hopefully that case will go further to the Court of Appeal now. Anyway, Omar tells us that, important points of principle are in dispute shouldn't necessarily go unresolved because they're continuously kicked into touch by individual decisions made after proceedings are instituted. So those are the points I wanted to make, yeah, that fitness to fly is an interesting area. It's been a live area for many years without really getting as much traction and without really getting any final clarity or resolution as to what the governing legal principles are. And I suggest it's something that's well worth having a think about in your own casework. Anyway, thanks for listening to me. I'm going to hand over now to our last presentation before we take any questions. So I'm going to hand over now to David.
Thanks very much, Mark. I'm just going to share my screen and hopefully you can see my slides. A few words of warning first. If you hear high-pitched screaming from my microphone, don't panic. That's my 14-month-old son. It will be fine. I apologise in advance. But what I'm here to talk about is the interplay between Article 3 and destitution adverse humanitarian conditions. The context is important as always, and in this particular subject, I think first principles are going to have to be revisited in light of AM Zimbabwe, and that's why it's important just to remind ourselves exactly what the context is for Article 3. The language of the article is very clear. It doesn't say very much other than that there is a prohibition on torture, and cruel, inhuman and degrading treatment. That obviously has to be applied in practice, and it has to be subject to interpretation. The interpretation, as we know, develops and changes over time, and what was previously considered not to be a violation of Article 3 may well now constitute a violation in light of that development. The interpretation of Article 3 essentially requires three key themes to be borne in mind. The first is the express terminology within the article and the implied terminology or the implied principles arising from the text. The second is the fact that the Convention is a constitutional living instrument, subject to change, as I've said. And the third is that the Convention is there essentially because it's based on humanitarian principles, and that's how it needs to be interpreted. What does all of that mean in practice? Well, the most common straightforward case we have is the paradigm case, and that was what Lord Justice Laws in J.S. India described as an intentional act which constitutes torture or inhuman or degrading treatment or punishment. So essentially an act from a state or a non-state actor. Obvious examples include where ill treatment is used to extract information or a confession. As we all know, the treatment has to reach the minimum level of severity, and that level is relative. It depends on all of the circumstances. That includes the country situation in which the individual may be returned to, and of course their own personal characteristics and vulnerabilities, age, gender included. What constitutes ill treatment has to be the subject of rigorous and detailed analysis, and consideration has to be given to what the foreseeable consequences are in light of the country situation where the individual would be removed, and as I say, their own individual circumstances. Non-paradigm cases are more contentious, and we've seen the development of those in a very incremental, slow, careful way. They concern circumstances where ill treatment is complained of, but not at the hands of the state or non-state actors, either directly or indirectly. It's long been accepted that Article 3 is sufficiently flexible to address those other contexts, and they are most obvious in perhaps two cases, so-called health cases. And you've already heard about the first one, the case of D, which Rebecca reminded us all about. Essentially there, Mr. D, as we know, was in advanced stages of terminal and incurable illness. Removal would trigger further reduction of his already limited life expectancy, and he would be subject to acute mental and physical suffering. His circumstances, according to Strasbourg, were truly exceptional and therefore non-paradigm, but worthy of protection under Article 3. The second most obvious case perhaps is that of N in the UK, where the Grand Chamber at Strasbourg revisited the health or so-called deathbed cases. That case was very different factually. Ms. N was HIV positive but receiving treatment. She was stable and relatively well at the time because of that treatment. The court said that the life expectancy reduction and the inferior treatment she was likely to receive in her home country was not sufficient to constitute the exceptional circumstances found in D. They did, however, say that there may be other exceptional circumstances where humanitarian conditions are equally compelling, as they were in D, so perhaps leaving the door open for other scenarios. In any event, they reiterated the high threshold in D and the need for that elevated bar where the acts or omissions complained of are not the responsibility of the state or non-state actors. Other cases have followed, and I've I query whether or not they are in fact non-paradigm cases. The first is MS in Belgium. That was a Dublin 3 case where the applicant was removed from Belgium to Greece, and the conditions in Greece for asylum seekers were extremely poor and included destitution. The court there accepted that extreme material poverty can raise, quote unquote, an issue under Article 3, and found that there was indeed an Article 3 breach on the facts in relation to that applicant. There were distinguishing features that were different from D. Perhaps 3 are relevant. The first was that the state in question, Greece, was under its own legal obligation through EU law to provide accommodation and decent material conditions for asylum seekers. The second was that asylum seekers constituted a particularly vulnerable group in need of special protection. And the third was that the breach of Article 3 would be taking or did take place in a state party to the convention. So not a third country that isn't a signatory to the European Convention. Query whether, as I said, that's not a paradigm case, because there you have the state indifferent at the very least of the conditions that individuals that they are legally responsible for are being subjected to. The second non-paradigm case I wanted to touch on very briefly is that of Sufi and Elmi. And again, Strasbourg returned to the issues and looked at whether or not the applicant's removal to Somalia would breach Article 3 in light of the dire humanitarian conditions there in refugee camps or IDP camps. There they found, again, a distinguishing feature that the conditions were predominantly due to the direct or indirect actions of the parties to the conflict. And therefore there was non-state actor acquiescence or responsibility, if you like. In those circumstances, they said it was the test, the Article 3 threshold in MS, not in N, that applied. And that required the court to have regard to the applicant's ability to cater for his most basic needs, including food, hygiene, and shelter. His vulnerability to ill treatment was also relevant, and the prospect of his situation improving within a reasonable time frame had to be considered as well. I'll come back to Sufi and Elmi in a minute, because it's still relevant, I think, for our purposes. But another case where the N threshold has reappeared, in fact, not the MSS threshold, was SHH and the UK. And again, there, Strasbourg underlined that the Article 3 risk, which was from potential destitution, the absence of medical treatment and welfare provision, all arose through an absence of resources by the state. The state was therefore not responsible. And therefore the N principles, the N threshold, if you like, had to apply. A similar example is also from the Court of Appeal case 2016 of Symes, where again the threshold was seen to be that of N when individuals who were at risk of being subjected to humanitarian conditions breaching in the IDP camps, again, but as we had seen in MSS, in Sufi and Elmi, but with a fundamental difference, which was that the conditions were not attributable to non-state actors or indeed to the state. They arose through humanitarian catastrophes in part, including an absence of water from a drought. So again, there, back to the N threshold when looking at destitution and adverse humanitarian conditions. How does that manifest? How does N apply in a destitution case? What does it actually mean? Well, according to the UK government's view, which was outlined in Sufi and Elmi, it means that where applicants are relying on dire humanitarian conditions, they have to show that the circumstances were very exceptional and that it was highly probable that the applicant would not have access to the basic necessities of life, and those deficiencies would result in an immediate threat to life or the impossibility of maintaining human dignity. So an astronomically high threshold, which is perhaps why we see very few destitution humanitarian conditions cases that are successful when N is applied. What does all of that mean now that we have AM Zimbabwe. You've already been taken to some of the key principles in that case, but their clarification was given to what constitutes the very exceptional circumstances considered before in Hen and clarified in Papashvili. There we're looking at the absence, although not an imminent risk of dying, the real risk of treatment that constitutes a serious or amounts to a serious, rapid and irreversible decline in the individual's state of health, resulting in intense suffering or a significant reduction in their life expectancy. My colleagues have also mentioned to you the procedural safeguards that arise in AM Zimbabwe as well. It's for the returning state to dispel any doubts raised by the applicant's evidence, which is capable of showing prima facie Article 3 violation. That consideration has to be on a case-by-case basis, and whether or not care is generally available in the receiving state is, of course, highly relevant. And the returning state has to consider the accessibility of the treatment to the particular applicant, including cost, the existence of family network, geographical location. That may well require assurances from that state, from the state being returned to, if there are serious doubts that continue to surround the impact of that removal. What does all of that mean then in respect of destitution and humanitarian conditions cases in respect of Article 3? Well, put side by side what is said in Sufi and Elmi and what is said in AM Zimbabwe as to the threshold in those very exceptional circumstances cases. In Sufi and Elmi, as I said, there's an immediate threat to life or impossibility of maintaining human dignity. In AM Zimbabwe, there's no imminent risk of dying, but there is a serious, rapid and irreversible decline in health, resulting in intense suffering or a significant reduction of life expectancy. So we can see immediately that the threshold that we're looking at is totally different, and one is far lower than the other. Also, bear in mind that the evidential threshold in AM Zimbabwe is a wholly new threshold and one that didn't appear in N. How does that manifest in a destitution case? What procedural requirements will apply to dispel any doubts and verify on a case-by-case basis that the treatment or the conditions and the personal circumstances of the individual will not be below Article 3 thresholds? The other thing that we'll have to think about in a little more detail is how, in those destitution humanitarian conditions cases, you evidence that risk of an Article 3 violation. What do you have to look to? What are the conditions? Of course, country background material will be critical, but also what is likely to happen in those specific conditions. If you're saying that the applicant will be destitute, what does destitution mean in practice in that country of return? Where will they be destitute? Is that in the city? Is that in a dwelling? Is it in an IDP camp? Is it in the countryside? If we're looking at humanitarian conditions as well, what's the extent of that? Are we saying that there is no food or clean water at all? Are we saying that it arises on an ad hoc basis? And then critically, how does all of that manifest for your individual applicant? What impact will that have on their well-being, their physical and mental ill health? Where all of this is going is unclear. I think Miranda's points about the parallel in suicide cases is also relevant to destitution and humanitarian cases. Throughout the authorities, as I've suggested, there has been a principled position, and that's of the cases that concern the states acquiescing and the cases that don't. And it seems that the cases that don't, N has always applied. And if that's right, now that N is no longer correct, surely from a principled position, AM Zimbabwe has to now apply. Just one authority seems to have looked at this, albeit in a roundabout way, since. That's the case of ASN and the Netherlands. That's a fourth section case from the European Court. That concerned an Afghan Sikh family who challenged removal to Kabul. Their refugee claim had been unsuccessful on the facts, and they argued in the alternative that there would be an Article 3 violation because of the humanitarian conditions they would face on return. Those included an absence of accommodation, an absence of employment, and an inability for the children within the family to attend a school, albeit, or attend a school safely. There, the court looked again at what was said in SHH and the UK, i.e. an N-type assessment and the need for very exceptional circumstances where humanitarian grounds against removal are compelling. Query whether or not they should have applied Papashvili and the principles that I've just gone through, bearing in mind that SHH is now questionable because of the clarity that Papashvili has brought. Consideration was given to Papashvili in that case at the very, very end of the judgment, but only in relation to one of the applicants' ill health rather than the humanitarian conditions that they would face. And on the facts, it was simply deemed not sufficient to trigger an Article 3 breach. So lots of food for thought, but I think at the very least, there is a clear change and development in relation to how destitution cases and humanitarian cases will have to be dealt with by the tribunal and by courts. Thank you very much.
Thank you, David. If anyone has any questions, please add them to the chat. So far as I can see, there are some from Cam, 3 questions. The first of those is on the question of assurances. Now, none of my cases have got to the stage yet where assurances are required. Can I ask anyone else on the panel whether they have been in a situation where it's been necessary to have assurances?
That happened in one of my cases, actually, the one I mentioned where I was quoting from what my opposite number had said. As I mentioned, that was a pre-AM case, but that was a case in which we were arguing that there was this high suicide risk for my client. The Secretary of State was very keen to deport him because he had a very serious criminal conviction. And in the course of the litigation, the Secretary of State not only made assurances, but adduced quite substantial evidence of treatment that she had arranged for him on return. And I think my takeaway from that experience was that it was really worth interrogating the nature of the assurances and of the treatment that was being put forward, because after a little digging, it appeared that there were quite a few gaps and holes in it, and it wasn't clear exactly what was being put forward or why it would be effective. I'm afraid, as that happened in the course of proceedings rather than as a result of our request, I can't answer Cam's question about how long is reasonable.
So Cam's second question, which I think is also probably directed to you, Miranda, was sort of query whether suicide is severe enough. Do you want to say anything about that?
Yeah, I think it's a really good question, and it's something that intuitively makes sense to say, well, if imminent death is severe enough, shouldn't suicide be severe enough? I think it's an argument worth trying to explore more, but I think that as these cases, suicide is inherently likely to be more speculative than death. It's not a matter of this is someone who is currently receiving this medication and as a matter of medical certainty will die within 2 days of it being removed. These are cases where you have the intervening act of the person. So I think it's more likely that you have to talk about the degree of suicide risk. Certainly if you had a medical consensus that it was all but certain that this person would commit suicide, I think that would very likely be severe enough. And all these cases are likely to win or lose on the basis of how well you can document that risk and its severity.
Thank you. And then Cam's next question was whether N was wrongly decided and whether N decisions can now be challenged. I think that's an interesting question. I mean, N, as I understand it, sadly died, so it's not going to avail her. But I think if you have clients who are HIV positive, then clearly, depending on their country and the stage of their treatment, then I think you can definitely run an Article 3 AM Zimbabwe case. And it will be interesting to see how that's dealt with. I mean, I can see the Home Office reusing all the arguments they used in N, but that's not to say that now the law has changed, that I don't see why that shouldn't work. The next question, Mark, this is from Kieran, because I know in your talk you had obviously thought about the difference between the CJEU and their interpretation vis-a-vis the UK in particular. So I'm going to hand that one to you.
Yeah, sure. Just remind me what the question was to which you were handing to me.
Sorry. What do you think Papashvili against Belgium and AM Zimbabwe tell us about Article 3 and how it is interpreted by the ECJ compared to the national courts?
Oh yes, okay, yeah. Well, it's interesting, isn't it? Yeah, I mean, the question we had put this dovetails really with that question that we were put, as you've indicated, on is N wrongly decided? Because of course, so the reason why we got into the Papashvili muddle was because we had N in the House of Lords, which is domestically binding on English and Welsh judges, whereas Papashvili was a Strasbourg court decision, which only had to be taken into account as per the Human Rights Act. So Papashvili is a December 2016 decision, and the UK catches up with it domestically in April 2020. So what about decisions in the meantime? I mean, one thing you could say, couldn't you, I suppose, is that it would be very hard to say that it wasn't arguable that the standard should be revisited from the moment Papashvili was decided, which in an amazingly grudging kind of way, Philip Sales kind of said, didn't he? And I think it was AM Zimbabwe itself in the Court of Appeal, very grudgingly, he said, well, anyone who arguably reached the Papashvili threshold would have to be given a stay pending the rapprochement between the cases eventually in the Supreme Court. As to Court of Justice land in the theatre of EU law, as I indicated earlier, it's pretty clear. I would say clear beyond argument, and no doubt we'll hear argument on it. That in the field of EU law, which is free movement law, insofar as it deals with health, and nationality law, e.g. Zambrano, both Articles 20 and 21 of the treaty, and in the field of asylum, because of the Qualification Directive, Procedures Directive regime, Papashvili has been controlling and not just vaguely relevant from the moment of its inception in December 2016, because EU law is bound by Strasbourg law in a way that domestic law isn't. So it's quite a rich tapestry there of things to think about in terms of historic decisions. But one thing is, it's very hard to me to see how anyone who was anywhere near the Papashvili threshold could have been lawfully subject to removal until the Papashvili correction was undertaken. I did actually, while I've got the microphone, there was something I wanted to say on David's interesting talk. There's a case that I recently did with Bindman solicitors, where we were in the Court of Appeal, and then the Home Office gave up on it in the end, where is another example of David's point about the switching thresholds depending on the degree of state responsibility. And so you have cases, as in the MSS Belgium and Greece scenario, where the Article 3 threshold was lowered, not because of Papashvili, but because of greater state responsibility, because asylum seekers have a legal entitlement to a minimum level of reception conditions under the EU Common European Asylum System. The same principle goes for people who fear a bad time in an armed conflict, because their problem is not driven by naturally occurring illness, but by human agency. And so they have a threshold, see Sufi and Elmi and the Article 15C cases in the UK. But the case I was talking about that conceded at sort of Court of Appeal level was one where the UK had removed a chap to his country of origin, and he had serious mental health problems, and he was humiliated badly during his expulsion, like he was put in a paper outfit in order to avoid self-harm incidents during removal. He was assaulted during removal, and that whole thing was very damaging to his psychological well-being. And also, he was then sent somewhere abroad where the UK seemed to be involved in funding his place of stay, and his mental health deteriorated subsequent to his removal. So there were two reasons, both treatment during removal and the UK agency in his stay abroad, which suggested that that wasn't a classic Article 3 case, it wasn't a classic foreign case either. It was a kind of a mixed foreign domestic case. So this issue of responsibility is a massively big one at the moment. Yeah, back to you, Rebecca.
Interesting, thank you, Mark. David, I think there's one for you from Natalie Wilkins about the type of leave that you could expect to get if you succeeded in a HPDL destitution case. I don't know if you have any experience of that, or anyone else.
No, good question. Query whether or not it would be within the rubric of humanitarian protection, within the immigration rules. And if so, then you're looking to 5 years, I think, 5 years limited leave to remain with a view to settlement thereafter. Obviously still with an active consideration of the country's situation. I think that's where we are. It will depend, though, on the facts and on what basis the Article 3 violation has been found. I think that's going to be key. One thing that is not, to my mind, hasn't ever been satisfactory is how the real end test fits to a humanitarian circumstances destitution case. I've tried my best to articulate how the courts have looked at it, and I think the best you get is what the UK government attempted to do in Sufi and Elmi. But it's not really satisfactory because the terminology and the language and the assessment was really geared towards mental and physical ill health. And that runs through the Strasbourg authorities. So what do you do in a destitution or humanitarian conditions case where you don't necessarily have that dynamic? And it requires some tweaking and a real change in approach. But as I said, that's what the courts are going to have to do now. And there's no getting out of that. The paradigm case has changed in terms of its test and assessment. Just to pick up very briefly, I think the first question was what to do with M cases now. I've just looked again at the judgment in AM Zimbabwe, and it's paragraph 27. I think it seems to suggest that had N been determined now on the Papashvili assessment, it would suggest a violation. So that's obviously something to bear in mind.
And just following up from that, David, looking at the chat, Cam has said she has a client who's recently granted HP rather than DL on an Article 3 case, but it might have been a mistake. I suppose that's the thing you don't know. I have to say I can see the Home Office trying to get away with 30 months, but then potentially that would be judicially reviewable, perhaps.
Yeah, definitely an area for litigation.
And Mark, Liz Barrett says that your case was eventually successful on Article 8 grounds in the UT, and they sort of avoided dealing with the Article 3 case, as is historic. Jo Renshaw has also posted the very sad news that one of her clients, who was a GS appellant, has died, still without status and living in poverty. I mean, the way those cases were dealt with was horrendous, not least because of the delay. One of the appellants was my client, and we couldn't even get him a transplant because he didn't have any status. And we even judicially reviewed that decision, and that was unsuccessful. So he was just stuck. We did take the cases to Strasbourg, but then they were stayed because of Papashvili, and the Home Office then agreed to look at them again. But of course, they're still ongoing, which is just wholly wrong on every level. That's not a very happy note to end on. Has anyone else got anything they would like to say, or other points I'd like to raise in the chat?
If I could say something on forms of leave, yeah, because again, that is a rich little tapestry of its own, isn't it? Because one, obviously, the starting point is whatever Home Office policy says it is. Two is that even if the Home Office policy says that leave is normally, whatever, 2 to 30 months on a 5-year or 10-year route to settlement or whatever, the case law shows, see a series of cases, all I think called S, which talk about the fact that a decision on settlement has to take account of the individual needs of the case. And so, perhaps slightly resentfully, all the modern forms of Home Office policy, which I very painfully dredged through for the new edition of McDonald's yesterday, every one of them says, exceptional, compassionate, compelling circumstances could require the grant of leave sooner rather than later. But also don't forget that some health cases can now edge into the environment of humanitarian protection. See MP in the Court of Justice, the Sri Lankan torture case. So humanitarian protection is now one of the very few species of international protection law that's changed its parameters in the 20 years I've been doing this. Because with the decision in MP, it moved onwards and recognised that even though you had no current risk of state harm, a failure by the modern state to treat your torture, your torture legacy, could be serious harm for the purpose of the qualification directive. So there's another example how a health case, something that might appear as a health case at first sight, could actually have a humanitarian protection dimension to it, and so itself be in the field of EU law. The only other thing I want to say, Rebecca did kind of make this point, I also shot it around in the chat, on assurances. There was a rich tapestry of law on assurances, yeah. So, I mean, the case law from the national security cases is that assurances have to reach a certain threshold. They have to be specific and credible, in good faith, verifiable, with a solid objective basis, disclosed, and any legal evaluation by another national court is relevant. So actually there is a standard by which assurances generally in Strasbourg have to be measured, and that will represent a whole lever to spark life into some of these assurance cases going forwards. Thanks.
Thank you, Mark. There was just one last question from Prime Solicitors. Please, can you just clarify, HIV patient well in UK, but condition could deteriorate in Uganda, can AM Zimbabwe apply? Well, I think based on what I said and what Mark's just said, the answer to that is yes, but you will need to evidence both the particular condition of your client or patient here and what the likely circumstances that he or she would face in Uganda, including access to treatment, living conditions, family support, ability to work, etc. But yes, certainly in theory, it's very arguable. And of course, also rely on David's point about paragraph 23 or 27 of AM Zimbabwe, where the court held that if N was now appealing, that she could succeed. So there's quite a lot of useful material that you can look at. Okay, there's another one. Does anyone have any thoughts on a case in which, between dismissal of a statutory appeal against deportation in the UT and applying for PTA to the Court of Appeal, my Nigerian client became extremely ill with COVID, went on the vent, induced coma and kidney dialysis in April, recovered whilst the PTA application was pending, but now has serious issues with memory, cognitive function and mobility. Ooh, this is quite interesting. So whether COVID would count from the point of view of Article 3 and removability. Any thoughts, panel?
Why not?
Do you mind? Why not? Yeah.
Yeah, I think potentially there's a procedural difficulty, I suppose, in relation to the basis on which the appeal is being run, and the post-hearing facts. Query, I suppose it depends, doesn't it, on what the grounds of appeal are, on whether, if those are successful and the claim is remitted back to the upper tribunal to be redetermined, then of course the tribunal would have to determine the breach on the date of the hearing. So those new facts and circumstances would come into play. If not, perhaps it's fresh claim territory.
I think that has to be right, because the illness postdates the previous hearing and application for permission to appeal. You can't suddenly bring it up as part of the application for PTA. So it would really depend. If that bit succeeds, you can then raise it. If not, then it's a fresh claim. Well, I think that's it for now. Thank you very much, panel, and hope that everyone out there found that helpful. Thank you.